So good afternoon to everybody. This presentation is based on a paper I wrote, which provides a historical overview of case law from different countries on non-human animal legal personhood. Today I will be focusing on some of the Latin American cases. Due to the time limit, I will mention some of the most important cases, as well as the findings and conclusions of my research. Okay, so most of the Latin American cases are habeas corpus cases that seek to attribute basic rights, such as the right to bodily liberty, to an animal. These cases have taken place in Brazil, Argentina, Ecuador, and Colombia. The pioneer case took place in 1972 when an animal rights NGO filed a writ of habeas corpus on behalf of all imprisoned birds that were sold, hunted, or poached in Brazil, requesting their freedom of flight. The court rejected the case, arguing that the writ could only be filed on behalf of humans. Some Brazilian scholars have interpreted this pioneer case as a metaphor directed against the dictatorship of Humberto Alencar Castelo Branco, who ruled Brazil between 1964 and 1985, rather than as a genuine attempt to obtain the recognition of birds' right to freedom. After this case, between 2005 and 2010, there were some writs filed in Brazil on behalf of chimpanzees. The most important case was Suiza's. Suiza lived alone in a zoo in Salvador. Two public prosecutors filed a writ of habeas corpus on her behalf, requesting the court to order Suiza's transfer to the Great Ape Sanctuary in Sorocaba, Brazil. The judge, Edmundo Lucio da Cruz, admitted the writ and granted the governmental agency responsible for the zoo 72 hours to present its arguments. The agency requested a second 72-hour extension, which was granted by the judge. Unfortunately, the day the court was supposed to decide the case, the respondent informed that Suiza had died the day before in the zoo. Therefore, the judge dismissed the case. And the judge stated that it was strange that Suiza had died because he had visited the zoo a week before and Suiza seemed to be okay. The thing is that Suiza was actually killed and her killers were never found. So even though this case ended tragically, Suiza's case is remembered as the first time a court recognized an animal as a subject that could claim her rights in court. And it has encouraged the debate on animal legal personhood in Brazil and the rest of Latin America. Jimmy the chimpanzee was forced to perform in a circus for many years and was then finally donated to a zoo. In the zoo, Jimmy lived alone and became famous because he enjoyed painting. The Great Ape Project filed a habeas corpus, which was rejected by the court because it did not deem Jimmy to be human. However, the judges debated the case for more than 3 hours, which was seen as a sign of doubt among them. At the same time, the Great Ape Project informed the governmental agency in charge of the zoo about the horrible conditions the animals were living in. The zoo was then finally closed and the animals were seized. As a result, Jimmy was transferred to the Great Ape Sanctuary in Sorocaba. So in this case, although the judges denied the habeas corpus, Jimmy was transferred to a sanctuary thanks to a parallel administrative procedure initiated against the zoo, which ended with its closure. In this sense, these type of procedures can be useful backups to habeas corpus in case these procedures fail. Jimmy's case also shows a certain evolution in judges' attitude towards these types of cases as they started to debate them instead of immediately dismissing them. Since 2013, several habeas corpus were filed on behalf of animals in different Argentinian cities. The majority were filed on behalf of chimpanzees, But a habeas corpus was also filed on behalf of Arturo the polar bear, who was internationally known as the saddest animal on Earth, and on behalf of Sandra the orangutan, who was recognized as a non-human person by some judges of the Federal Criminal Cassation Court, one of the highest courts in the country, although she was finally transferred to a sanctuary thanks to another type of procedure, not the initial habeas corpus. The first, let's say, legally successful habeas corpus case took place in Argentina in 2016. Cecilia, who you can see in the picture, was recognized as a non-human person and granted the habeas corpus. Cecilia has been living in Brazil's Great Ape Sanctuary since April 2017. And this case was easier than most studied cases because all the parties finally agreed to send Cecilia to a sanctuary. This picture was the first day that Cecilia arrived to the sanctuary and the first time she stepped into her yard. So there is another case in Colombia. Chucho and Clarita, his sister, were Andean bears that lived together in a natural reserve in semi-captivity for most of their lives. Clarita died from cancer in 2008 and Chucho became severely depressed. Therefore, the environmental authority of that region decided to transfer him to the Barranquilla Zoo in June 2017. A local lawyer filed a habeas corpus arguing that Chucho had the right to return to his natural habitat. The Superior Court of Manizales denied the petition, so this lawyer appealed to the Civil Chamber of the Supreme Court of Justice, that is one of the highest courts in the country. The judge, Luis Armando Tolosa, overruled the judgment and granted the habeas corpus on July 26, 2017. So the zoo presented a tutela, that's an action, another type of action that protects fundamental rights, to the Labor Chamber of the Supreme Court of Justice. This court granted the tutela and agreed with the zoo that the habeas corpus violated its fundamental rights, such as the right to a due process. This decision was appealed to the Criminal Chamber of the Supreme Court of Justice, which confirmed the decision. So after this, the Constitutional Court selected the case for revision. This court has the faculty of revising tutela judgments, and some of the judges of the Constitutional Court insisted on selecting Chucho's case for its novelty and the opportunity to expand the court's jurisprudence on animal rights. In January 2018, Judge Diana Fajardo, who you can see in the photograph, was designated as the judge in charge of Chucho's case. Judge Fajardo asked for expert opinions on the case as soon as she received it and even organized a hearing, which was held on August 8, 2019, where various experts in animal law and ethics were heard, such as Paula Casal, the Spanish philosopher and president of the Spanish Great Ape Project, and Stephen Wise, president of the Non-Human Rights Project. The picture on the slides is a photograph that was taken during this hearing. At the end of January 2020, the Constitutional Court rendered its verdict. The court decided to confirm the tutela judgment, denying the habeas corpus. According to the court, the habeas corpus is not an appropriate mechanism to resolve an animal welfare dispute, because the writ seeks to protect persons' right to freedom and mentioned that there are other mechanisms to protect animals. The judges also stated that animals are not subjects of rights in Colombia, but rather sentient beings. However, Judge Fajardo had proposed a ruling that granted Chucho the habeas corpus and recognized him as a legal person entitled to freedom. This proposal was supported by 2 of the 9 judges of the Constitutional Court. So Judge Fajardo finally criticized the court for remaining stuck in a formal approach of the law without building effective mechanisms to protect animals. Despite this dismissal, Chucho's case has been a historic case in Latin America, not only because a higher court granted a habeas corpus to an Andean bear, but also because this debate has elicited contradictory opinions on legal personhood and animal rights from different chambers of the Supreme Court of Justice and among the Constitutional Court's judges. And normally such cases are dismissed at a lower court level. So even though the court denied this habeas corpus, it had an active and serious role in the case that's quite unique at a global level. The court had no obligation to review this case, especially considering that it would have to review the judgment of one of the other highest courts in the country, the Supreme Court of Justice. And then we can see Judge Fajardo's unique role in the case, where she asked for reports from experts and held a hearing when actually a hearing is not required in these types of procedures. So after reviewing the cases, the first thing that pops up is that even though some initially consider these cases as ridiculous or having low chances of success, attempts to accord legal personhood to animals have exhibited an increase in number, as well as in the variety of species and countries involved. And their ability to reach higher courts has also increased. As this historical account shows, legal personhood for animals has come a long way. Initially, there was one case a year at the most, usually regarding a chimpanzee. But during the last decade, we have seen several a year regarding different species. As the frequency of cases has increased, the attitude of judges has also begun to change. The opinion that these lawsuits are ridiculous has been replaced by longer deliberations at higher courts, as Jimmy, Sandra, and Chucho's cases show. Moreover, courts have started to recognize that they can no longer simply dismiss a habeas corpus because the animal is not human, considering social pressure and the evolution of case law on animal protection. Reflecting on the development of the cases, dismissal strictly based on membership to the human species was not the main trend. In most cases, courts examine legal personhood. However, some courts still prefer to dismiss these types of cases on procedural grounds. Additionally, the success of such cases does not depend mainly on the animal species, genetic closeness to humans, or cognitive abilities, but instead on other factors such as strategy, the technical aspects of a habeas corpus, and the judge's empathy towards animals, willingness to hear a novel case, and general philosophical outlook on law. If such cases depended strictly on genetic closeness or cognitive abilities, then chimps would be the most successful species in court. But in fact, only one chimp case has been successful. The other cases that were granted by a court but later reversed involved an orangutan, the great ape that is genetically most distant from humans, and an Andean bear. So after checking these 20, I checked 27 cases, 3 dilemmas were revealed. The first concerns the pros and cons of employing legal versus political means. The second concerns the advantages of habeas corpus versus other legal strategies. And the third concerns whether legal practitioners should attempt certain cases that have a very low probability of success. In some of the examined cases, judges have argued that a petition to recognize animals as legal persons should be made to Congress and not to the courts, as happened, for example, in Chucho's case. We probably all agree that the purpose of these lawsuits is to make things better for animals, not worse. However, there is a dilemma when deciding whether to fight for animal personhood in court. A case with a high chance of success could lead to the animal in question being killed, as occurred in Suiza's case. The political struggle for a bill on animal personhood does not face this dilemma because a bill would not target an individual animal, but one or more species instead. However, the fact that several animals have died during these lawsuits, such as Suiza, or a couple of years after the case ended, such as Arturo the polar bear, shows that these cases are truly urgent. All these animals have suffered greatly from physical and psychological illness due to captivity. Therefore, in most cases, there is no time to start a political process in Congress. Political strategies for animal personhood might be a good option in the long run, but they may not be enough to help animals that are currently suffering the consequences of captivity. Furthermore, seeking a bill on animal personhood is not only a slow endeavor, but a difficult one due to all the lobbies that would oppose it. Hence, animal rights advocates are kind of forced to seek help from courts and mainly do so through habeas corpus. Some might argue that all the judicial defeats proves that this option is even harder than the political endeavor. However, judges have started to accept the habeas corpus as an adequate legal action because there are no other available mechanisms for requesting the animal's freedom, and judges are required to solve the case, as Cecilia's case demonstrates, as well as Judge Fajardo's dissenting vote in Chucho's case shows. Animal rights advocates must consider that some courts confuse the terms human and person as synonyms, as Judge Rojas' dissenting vote in Chucho's case highlighted. Moreover, some judges and attorneys seem to fear the effects that the judgment might cause in other activities that use animals, rather than focusing on the specific animal plaintiff, as Chucho's hearing proves. Therefore, this judicial fear affects the animal plaintiff's chances of being recognized as a legal person with certain basic rights.
5 minutes left, thank you.
Okay, thanks. Even if it were true that the habeas corpus presents this peculiar difficulty, it is not the only mechanism to argue for an animal's legal personhood in court. For instance, there are 2 animal cruelty cases in which the judges recognized the abused dog's legal personhood on their own motion to stress how much these dogs had suffered and the seriousness of the offense. In this sense, having different strategies is positive, as there is uncertainty about which legal strategy has more chances of succeeding. Nonetheless, advocates must bear in mind that animals in zoos and labs are fragile, and so administrative procedures or other types of lawsuits that might take years could take too long and the animal could die in the meantime. So initially, attempts to obtain legal rights for animals were considered unlikely to succeed, and probably any attorney can agree that there are some legal strategies that have a greater risk of creating a negative precedent than others. The point of contention is how animal advocates should act in view of those cases that have a very low probability of success. Should they go ahead with these types of cases? In any case, going ahead despite the low probability of success has had several beneficial consequences. For example, even fragments of judgments that were inconsequential or unsuccessful can be exported to other cases with a positive effect. For example, obiter dictum declarations and judgments can still influence other national or international judgments. In fact, the Federal Criminal Cassation Court's judgment in Sandra's case inspired the judge in Cecilia's case. And in Sandra's judgment that was overturned is still quoted as an exemplary case around the world. For example, it was mentioned in the judgment of the case involving the Marghazar Zoo in Islamabad. Partly because of this phenomenon, animal legal personhood has become increasingly supported by judges, well-prepared attorneys, renowned scholars, and scientists from around the world, showing that these cases are neither ridiculous nor frivolous, which normalizes the topic among the public. And an impact on the media and the public's growing familiarity with the possibility of animal personhood, as well as the general public's emotional involvement with specific individuals like Sandra, Cecilia, and Chucho, mobilizes courts and governments to act. So this is my email in case anybody wants to contact me, and I will be happy to answer questions at the end. Thank you.
Lovely, thank you so much. Thank you, Paulina. On to our final speaker today. Oh, in my throat, sorry about that. So we have Thomas Aiello speaking. His title of his paper is Police Brutality and the Nonhuman in the United States. Thomas is Associate Professor of History and African American Studies at Valdosta State University in Georgia, USA. He is also a doctoral student in anthrozoology at the University of Exeter, studying critical animal studies and the history of American speciesism. I can see your slide. Thank you. Welcome. Over to you.
Thank you. So police brutality against humans in the United States is a massive story and a massive problem, and has been for a very long time. But between 1998 and 2014, police in the United States also shot 6,083 dogs, More than half of all intentional police shootings in the nation involve animals, and dogs in particular. While officers who work with canine dogs receive special training before entering the field, only a small handful of departments across the country provide animal behavior training for officers not specifically tasked with patrolling with a canine partner. And only Colorado requires such training. That lack of training, combined with the broad default position among police that unknown quantities who don't display similar physical characteristics to the officers themselves are potentially expendable threats, has proven inordinately deadly for non-human animals in the United States. With an average of almost one dog shooting every day since 1998, the consequences for the animals themselves are obvious. But there is a human toll as well, as the families of companion animals are devastated by the loss of a family member taken from them, usually without cause. There's also a decidedly human racial element in police shootings of dogs, the majority taking place in Black and brown neighborhoods. There are more than 77 million pet dogs in the United States and millions of others not part of a human household. Among the homes that include dogs, 2/3 describe pets as constituent parts of the family. Still, they are considered property, not persons, in the eyes of the law, as we just learned, which makes them more vulnerable in encounters with police. That property status, then, leads challenges to police brutality against animals to build from the Fourth Amendment's prohibition of unreasonable searches and seizures. Then there is the same qualified immunity that shields many police officers from prosecution in shooting cases with human victims, a defense strategy occasionally effective when police shoot non-human victims. Law enforcement gains immunity in such cases if the shooting, one, does not violate clearly established statutory or constitutional rights, or two, when a reasonable person should have known. A legal precedent that has protected countless officers in shootings of both humans and non-humans. Even when qualified immunity doesn't apply, however, police are often shielded from financial liability by a variety of other defenses, and entirely shielded from criminal liability by animals' lack of standing. Understandably, a decidedly racialized effect of qualified immunity in police shootings of Black and brown non-humans has also translated into violence to their pets. In a geographical analysis of police and sheriff's deputy killings of dogs in Los Angeles, Stefano Blocca and Daniel Martinez demonstrate that the bulk of shootings take place in the same Black and brown neighborhoods in which the police commit the majority of their human shootings. The wanton disregard for Black and brown human life by police, then, affects the lives of the animals who share those Black and brown homes. Violence, argue Blocca and Martinez, committed against canines in these communities is an expression of larger trends in a state violence that routinely takes place during the serving of search warrants, as part of stops and frisks of pedestrians, and as a result of investigatory traffic stops that disproportionately target communities of color. The case law attempting to reconcile animal status as property, the important role they play in the lives of human families, and the constant violence enacted on them by police began substantially in the 1980s. In August of 1984, for example, sheriff's deputies in Manitowoc County, Wisconsin, executed a search warrant on a family home, seeking a cache of marijuana and some stolen pressure cookers. They entered the house in camouflage and moved quickly to secure the premises. They found neither marijuana nor pressure cookers, but in the process of securing the house, one of the officers shot and killed the family's German Shepherd. When the family sued, the original jury in the case awarded them monetary compensation for loss of the dog, as well as punitive damages. It also required funding for officer training related to canine interactions. Appellate courts, however, as we saw in our first paper, found the punitive damages as problematic, and the Seventh Circuit Court of Appeals remanded the case for a new trial in 1989. The court was clear that the shooting was a Fourth Amendment violation, a functional seizure of the family's property, but worried about punitive damages for what was interpreted as a loss of property rather than the loss of a member of the family. It would prove a common appellate interpretation. Courts validating Fourth Amendment claims based on cruelty to non-human animals, but refusing to describe that validation as a form of brutality. Seizure claims ensured victims a measure of monetary compensation, but that compensation was typically limited to the fair market value of the dog, not based on a serious interest in the life taken or the psychological damage to the family. It was a form of speciesism that ensured the financial culpability for offending officers in their departments would be minimal, leading to a shoot-first attitude that presumed dogs to be potentially violent threats rather than innocent bystanders. The standard was all the more galling when considering common law culpability for pet owners after events like dog bites, built from the assumption that dogs were not inherently violent at all, a standard in US law commonly known as first bite free. Civilian victims of dog bites had to demonstrate in court that pet owners had a reasonable understanding of a dog's potential for violent action to prove culpability and get financial restitution. Police, however, could assume the opposite and thus feel relatively unfettered in killing pets indiscriminately. There were, however, exceptions to that rule, wherein larger restitution could be made. Fuller v. Vines in 1994 involved the shooting of Champ, a 12-year-old Great Dane Labrador mix, while lying in the grass at his home. A father and son were with him when two police officers walked by. Startled at the presence of pedestrians, Champ stood up, prompting the officers to draw their guns. Both father and son begged them not to shoot the dog, but they did anyway. And when the son protested, they turned the gun on him. As in most of the cases resulting from police brutality against dogs, the Ninth Circuit Court of Appeals treated the resulting suit as a Fourth Amendment property seizure. And after remanding the original suit back to the trial court, a jury awarded the Fuller family $143,000 for violation of the family's constitutional rights, another $10,000 in punitive damages, and more than $100,000 in additional money for pointing the gun at the son. Fuller demonstrated that juries were more sympathetic to the bonds between human families and non-human companion animals than judges, but even with a heavy payout, the case was still the result of a civil action. The officers never faced charges and knew that Fourth Amendment seizure claims for killing dogs would never end in the kind of prosecution that would force them to face non-monetary consequences for their actions. The case law is important because it demonstrates the evolution of legal thinking on police brutality towards animals, but the one static entity in the legal system kinetically negotiating its relationship with police violence toward the non-humans in their midst is that wanton indifference. The evolution of legal thinking, then, is about classification rather than prevention, restitution rather than punishment. And so animals entering the policing space in an inordinately vulnerable position. One of the foundational cases governing such assumptions in the 21st century is Rabideau v. City of Racine in 2001. After Wisconsin police shot and killed Dakota, a dog living with Julie Rabideau, the judge in her case awarded the human plaintiff recovery for emotional damages based on the fact that she witnessed the killing. Rabideau argued, anyone who has owned and loved a pet would agree that in terms of emotional trauma, watching the death of a pet is akin to losing a close relative. The Supreme Court in Wisconsin, though acknowledging that bond, disagreed. The law categorizes the dog as personal property despite the long relationship between dogs and humans, the opinion read. And that being the case, petitioners cannot maintain a claim for recovery for the emotional distress caused by negligent damage to her property. That unwillingness by the court to countenance the human relationship with animals above and beyond their common law property definition served as a form of further permission for police officers to treat animals with relative impunity. That same year, the Third Circuit Court of Appeals evaluated a Pennsylvania case wherein Emmy, a Rottweiler, wandered into a parking lot adjacent to her house while her humans were in the process of moving. When approached by a police officer, Emmy barked. Despite her bright pink collar and tags, and despite her owner screaming from the window of the home, the officer pulled his gun and shot Emmy 5 times, even continuing to shoot her as she attempted to crawl away. The court, in the resulting case, Brown v. Muhlenberg Township, was concerned in particular with the qualified immunity claimed by the officer, and it denied it based on his breach of Fourth Amendment seizure laws. Police have proven willing, if not eager in many cases, to take the lives of human victims, even when they are being filmed, because of a confidence that qualified immunity will protect them. In instances of police brutality against non-humans, there is a reverse assumption at work. Claims of qualified immunity have been consistently struck down by courts precisely because animals are considered property. Fourth Amendment search and seizure violations rise in their place, but never generate the possibility of jail time or other legal jeopardy for officers involved because the issue only arises in those civil actions. Thus, while qualified immunity has historically served as at least a partial motivating factor in the police shooting of humans, the lack of criminal prosecution in Fourth Amendment civil cases has become its own version of qualified immunity that creates a similar willingness to kill when officers encounter dogs in public spaces. And as in police brutality cases against humans, the assumption of at least an approximation of immunity lends a de facto credibility to officer narratives of events. In Altman v. City of High Point, North Carolina in 2003, for example, animal control officers, rather than the police, killed several dogs, but they made a similar claim for qualified immunity. The Fourth Circuit Court of Appeals again rejected the claim, but absolved the officers of responsibility because the dogs were Rottweilers, pit bulls, and large dogs of mixed breed that defendants were able to depict as aggressive and dangerous. A successful form of profiling so common in defenses of human shootings. The next year, a Connecticut court ruled that a police officer was justified in shooting a pit bull running toward him, despite the dog's owner telling them that he was friendly. That reliance on profiling offered another intersection with the racialized history of policing. Just as racial profiling and stop and frisk policies provided permission for police officers to abuse civilians based on their own inherent fears of the other, breed assumptions gave them similar cover for similar violent interactions. In a 1998 police raid at the clubhouse of the San Jose chapter of the Hells Angels motorcycle gang, police shot 3 dogs who belonged to members of the group. Guard dogs who were not only large and assumed to be aggressive, but who were also by default associated with the Hells Angels, despite the fact that dogs do not carry the same cultural constructs to allow them to know or care about motorcycle gangs. Not only did the police kill 3 dogs on the property, but one of the members of the Hells Angels was handcuffed just yards from where her dog, Sam, lay dead and bleeding. It was the ultimate trauma for Sam, and a substantial one for his arrested human companion. The officers predictably claimed qualified immunity, but the court disagreed, arguing that plans for the raid had been made weeks in advance, giving police ample time to develop strategies for immobilizing, quote unquote, the dogs without killing them. It was both an unreasonable search and an unreasonable seizure in violation of the Fourth Amendment based on a lived intersection of human and animal stereotypes. Demonstrating the legal myopia presented by courts, another federal district in the same year granted for the first time a qualified immunity claim for a police officer after shooting and killing a dog, despite the fact that the court accepted the plaintiff's claim that the dog did not bite and that he could easily have just been put on a leash. The officer, the court claimed, could have reasonably assumed that the dog posed an imminent threat to his safety, and thus he is objectively reasonable in his belief that his conduct would not violate clearly established law. It was a narrative familiar to African American plaintiffs since the recorded beating of Rodney King in the early 1990s, the court giving the benefit of the doubt to a police officer's reasonable assumption of danger based on no demonstrable data. And as the families of victims from Amadou Diallo to Freddie Gray knew all too well, those baseless assumptions ended in death was of legal little concern in such decisions. And just as in those human decisions, the court's acceptance of a qualified immunity claim carried with it consequences for future lawsuits. creating a stare decisis domino effect that made it more difficult for claims against police officers who killed pets in violation of the Fourth Amendment.
5 minutes left. Thank you.
Sure. In 2008, the Seventh Circuit Court of Appeals upheld qualified immunity in the Milwaukee police killing of Bubba, a 7-year-old Labrador Retriever Springer Spaniel mix. Despite the fact that Bubba was sitting in his yard staring at his human companion, the officer who shot him claimed he felt threatened, and the court was inclined to take him at his word, arguing the use of deadly force against a household pet is reasonable only if the pet poses an immediate danger and the use of force is unavoidable. Though shooting Bubba was clearly avoidable, the ambiguity of such terms gave the legal apparatus the ability to provide cover for law enforcement. In 2010, however, the Northern District of California also denied a qualified immunity claim, not because of grotesque cruelty or because qualified immunity couldn't apply in the police shooting of a non-human animal, but instead because officers who killed an animal while executing a warrant knew that the plaintiff's dog was in the house before they entered. That left Fourth Amendment claims, which the courts on 2 different occasions in 2010 and 2011 argued could apply to police shootings of non-humans even when the victims were only wounded. Still, demonstrating the perfidious shadow of assumptions about qualified immunity and reasonable fear, both of those cases ended in summary judgments for the police defendants because the courts deemed the shootings, again, reasonable. In a case that would find human echoes 7 years later in the police killing of Breonna Taylor, Carroll v. County of Monroe in 2013 upheld a lower court ruling that justified the law enforcement shooting of a family dog while executing a no-knock warrant in Monroe County, New York. Sheriff's deputies used a battering ram to break down the plaintiff's door, understandably distressing the dog who lived in the home, leading him to growl and bark at the entering officers. One of the deputies responded by shooting the dog in the head with a shotgun upon entry. But the court ruled that the aggression of the dog was justification enough for the shooting, despite the aggression being caused by the use of a no-knock warrant. The problematic nature of that kind of successful circular argument would become all too familiar in 2020 in Louisville, Kentucky, after the execution of a no-knock warrant and the understandable aggression of one of the home's residents led to indiscriminate shooting and the killing of Breonna Taylor. The public outrage over the lack of police consequences for the attack was international in its scope, a macro version of what pet owners had experienced for years in cases like Carroll. The clear comparison between the different kinds of official othering and the lack of consequences for it would be obvious to police brutality's human victims, particularly those among the African-American population, leading to a glut of non-human animal symbolism in commentary on racialized policing. The police are treating us like dogs. After the metaphors ran their course, however, there were still the tens of thousands of dogs shot and killed by police. In 2016, the problem was made most public by the documentary Of Dogs and Men, which examined in depth the disturbing trend of police shootings of companion animals. The ASPCA, the Animal Legal Defense Fund, and other advocacy groups have sought to create training programs for officers and funding pools for Fourth Amendment court challenges for victims of police abuse. Advocates created the Puppycide Database Project to track police shootings of dogs and other non-human animal companions. Whether you're talking about police shooting dogs or citizens, explains attorney John Whitehead, the mindset is the same: a rush to violence, abuse of power, fear for officer safety, poor training in how to de-escalate a situation, and general carelessness. And whether you're talking about dogs or citizens, the results have historically been catastrophic and deadly. And since the veritable mass killings of dogs by police in the United States doesn't spark international vigils, we are left with case law and an overt need for police reform. Thank you.
Thank you so much. Wow. Okay, so we have some time for questions. Yeah, some claps there coming through for you and for our first two speakers as well, I'm sure. So if you want to ask a question privately or anonymously, please use the chat function. Otherwise, if you want to raise your hand, I can invite you to ask a question to any or all of our speakers. And if you're happy to turn your cameras on now, you're welcome to do so. If you're not comfortable doing so, that's fine as well. Do we have any questions? Sometimes it takes a moment to reflect on what we've just heard. Or even if our speakers have any questions for each other, I'm sure maybe your work inspired thoughts for your own research as well. So if you would like to ask questions of your fellow panelists, that would be fine as well. Anybody question? I think maybe everybody's a little heavy-hearted from that final talk. I know I am, but yeah.
I guess I have a question for Tom.
That would be lovely. Yeah, thank you. Go ahead.
Lovely talk, Tom. Thank you so much for that presentation. I was just wondering if the attitudes towards the police brutality against the animals, if there is sort of overall a solidarity stance, or is there a clear human first approach to the groups, like within the advocacy groups for the dogs? Is there a clear separation, or is there like an alignment?
There is an alignment, but it only goes one way. So the people who advocate against police brutality against dogs also point out that American police are just mass murderers in general, and talk a lot about the various racial instances that happen all over our country all the time. We don't really see that go the other way, though, because most people, unless they're attuned to animal concerns, simply don't know much about this. For most municipalities, animal court in the United States is completely separate from human court. So you go to a completely different court, you go to a completely different courthouse with a different judge, and it's just not often seen. On top of that, there is this kind of myth making about police and their canine dogs and how they're chummy and buddy, and how dogs are part of the police and they're, we love them all. Even though that, of course, isn't true. Canine dogs are abused often. And there are several instances of case law that I didn't bring up that very much involve the police killing their own canine dogs because they found them to be not useful anymore. So I think it's just a matter of people not really understanding and just being overwhelmed by the constant news of the shootings of humans that they do all the time. But it does go the other way. These puppycide database people are very much on the front lines of, the George Floyd and everything else protests. So it does go one way.
Did you want to respond at all, Paulina? Are you happy? Okay. Thank you. I have a hand up for Amani. If you'd like to unmute and ask your question and or turn your camera on if you like.
Yes. Okay. So thank you very much, all three of you. It was very interesting. I will not say it was very nice. I can not to hear about it, but it was very, very interesting. I have one question for Thomas directly, and then I have another question to the whole personhood in law concept, as it was discussed today or in your talks. The one question is, you mentioned that, like in the end of your talk, Thomas, it to me at least, it sounded as if the dog shootings preceded the human shootings in a way, so that the police was desensitized, but I don't believe that's the case. I'm just making sure. And the other thing is there any sort of, like, can you see, apart from most of the dog shootings being in black and brown neighborhoods, have you seen anything like white dogs, like white owned dogs, or however you would call that, being treated any differently, like on the street or when they are misbehaving or whatever, like in those cases? And maybe just so I can mute myself again, just posing the other question right off the bat, is I am in a way acquainted with the legal personhood concept, but what was new to me was this idea that like a lot of the cases, the historic cases, I didn't knew about actually. I knew about Sandra, I knew about Chucho and Cecilia, but a lot of that was not known to me. And what was also new to me was that there is in a way a difference about just broadening the concept of personhood and the suggestion that the concept of personhood needs to be redefined, but in a sense, to me at least, in the end it sounds the same, like a broadening of the concept, just taking another turn to get there. And maybe you could clarify that a bit for me. Thank you.
So the police killing of dogs does come after the police killing of humans. The police in this country were established specifically to control minorities and to kill them. From the very first municipal police force in the 1830s, it was specifically designed to police minority neighborhoods. The whole concept behind policing in our country is specifically to attack the other. So while the killing of animals and the drawing of that species line and that human supremacy very much came first in the country, the police use of force against animals comes after their long conditioning of using force against non-white populations across the country. So while killing of animals obviously came first and human supremacy comes first, police role in that fed more from the human killing than the other way around. And the reality is, while I thought my co-presenters were amazing and did a great job, especially with this concept of personhood, which plays such a role in these suits, the reality is personhood standards won't help for police shootings because the police here have proven they don't care if you're a person or if they think you're not a person, they'll still kill you. So I will bow here and let my co-panelists answer your question about personhood, because I'm probably not in the best place to answer that.
So if I may just go off of Tom's point, I think the key difference between what I would call the extensionist approach of personhood versus redefining is that when you're extending personhood, which carries with it in the Western legal world, carries with it a certain conceptual baggage of what it means to be a person, we historically have been extending this specific concept, which was originally made for able-bodied, white, male, property, et cetera, human beings. And we have continuously, without contesting this idea of what it means to be a person, while extending it to other groups, not actually challenging what it means to be a person. So that is like not an explanation of why we still have oppression of certain groups, but it is part of the issue of why certain individuals, the majority of people and all non-human animals, are still excluded from the idea of what it means to be like have moral status. So by redefining it, we are the only reason why I still am keeping the idea of personhood and animal personhood is the rights-bearing significance. But other than that, we're literally scooping out all of that baggage. Oh, it's like certain traits, it's a certain type of human being, erasing that and redefining it in animal terms. And that's by centering the animal, it gives all humans and non-humans an ability to define what it means to be a person for themselves in a very inclusive way that does not have any of that old baggage. But that's just my response.
So there wasn't really a question for me, I think. But speaking of the cases, yeah, actually Cecilia, Sandra's, and Chucho's cases are the most famous ones, maybe the ones that were most covered internationally. But Latin America is the region in the world that has more cases on personhood. And you can find, for example, even now that we're talking about dogs, you can find at least 2 cruelty cases where a person mistreated a dog, and the judge decided in the judgment to say that these mistreated dogs were persons, and understanding them as subjects of rights, and applying, for example, in one of the cases, Sandra's judgment, Sandra's an orangutan, but applying this judgment to a cruelty case just because the judge felt that this case was the abuse was very extreme on the dog, and this judge felt empathy towards dogs. So we can see that in some of these cases, legal personhood is linked to great apes or elephants, for example, in the US, or even orcas or dolphins. But you can see that companion animals could have a strong position before judges on personhood, because it's easier for a judge to feel empathy or towards a dog because maybe this judge has dogs at home. So this is like an advantage that dogs have, or other companion animals have, versus animals in the wild, for example, or animals in labs or in zoos.
Thank you. We have another question, Esther, if you would like to unmute.
Yeah, thank you to all of the speakers. It was really, really interesting. So yeah, thanks. My question is for Macarena and Paulina. And yeah, I guess this is something that I've been reflecting on as well. But I guess it's kind of this, I'll give some background to this question just a little bit, but in activist spaces, like, we're generally kind of competing between, you know, what's our real kind of vision for the world, what's the world that we really want to bring about, and what are the kind of pragmatic things that we have to do that sometimes like compromise some of our like principles to actually, you know, to actually bring about these visions. So I guess in relation to personhood, like I've come across Manisha Dekker's like criticism of personhood. And then I guess I've also come across arguments in, you know, saying that, you know, this is our most kind of like obvious avenue, and the thing that's most available to us to kind of challenge our systems of like justice. Yeah, so I guess what, yeah, so what's the kind of, I wonder if you could comment on that, like, you know, how do we balance what we really, really want, and, you know, what's kind of most available to us? Yeah.
So I'm an attorney, okay? So I'm always like balancing what you can do in court and what is harder to do in court. Like when you litigate, you always have risks. Like in any type, not even in animal cases, but in any type of litigation, you have a risk of winning or losing. So there's a lot of strategy involved in litigation. Courts around the world, after the research I've done, that's around, I think, like 27 cases I examined, judges are starting to associate legal personhood with animals. Like some years ago, they would say, what's this? This is frivolous. This is ridiculous. Like, no, and dismissed it. But now, and there are judges that are starting to say, yeah, this makes sense. And some judges are starting to say the habeas corpus, the writ of habeas corpus, can be used for animals because there are no other mechanisms for animals. Like there's not another type of procedural action to free an animal. So some judges around the world are already saying, oh, the habeas corpus is the adequate mechanism because I'm a judge and I'm forced to solve the case. So as there isn't anything else, judges are accepting this. And with time and with activists and different NGOs presenting more and more cases on animal personhood, this starts to sound normal for, I don't know, for scholars, for scientists, and that start supporting these cases through and during the procedures through amicus, like these reports that they present. So I truly believe that we can advance and we can start breaking like this wall of like this huge wall of personhood that separates humans from the rest of the animal kingdom. But it's going to take time because we're dealing with judges and this whole procedural structure that's really hard to navigate, and judges, most judges have never had an animal in court, an animal plaintiff. So it's the first time that they're maybe hearing, hey, this animal is a sentient being, this animal has these cognitive abilities, this animal has a family, this animal has friends, blah, blah, blah. So judges don't know much about animals, except that maybe some of them might have dogs at home. So I think if we kept pushing this this topic on this animal personhood and explaining to judges that person is not synonymous to human, and insist on that because they're still confused with this, some judges are starting to get it, and not just in Latin America. We can see the judge in Pakistan with Margazar Su judgment, and some, well, judges in India and Latin America and different countries. And well, Europe is still behind, but even the Non-Human Rights Project has had some advances in the US, with some judges saying, hey, I can't admit the habeas corpus, but I understand what you're saying, and this elephant is, for example, regarding Happy the elephant, this elephant is a subject of right. So I think we have to keep pushing it because we know that, yeah, in Europe, it's the only cases, well, in the chat is Heisel, the chimpanzee case, but none of the courts wanted to analyze if the chimpanzee was a legal person or not. All of them dismissed the different courts dismissed the case on procedural grounds because they refused to enter and analyze legal personhood. But I am a firm believer that the category of personhood is useful, because right now we only have, or you're a thing or you're a person, or now what they're saying in Latin America for certain animals in certain countries that they're sentient beings, like that's a third category. But it's like the same as being a thing, because they're saying no, animals are not persons, they're sentient beings, and that way they're getting, like, they're trying to solve these cases. But I think advocates have to keep pushing, but because there's no other category. And I truly believe that sentient animals are persons. Like, legally, they can be persons. We have the legal structures. We have guardianship to represent animals' interests, etc. So I think we have to keep pushing, and with the years, there's going to be more and more advances in this topic.
So I just wanted to add to that from like a different perspective, because thinking about this, like, kind of just from a philosophical point of view, the way that I would approach the question of activism is that our activism should not be carried out in a way that oppresses other groups. So we have to sort of have this intersectional ideology. So if we're zeroing in on, for example, a specific racial liberation issue, we cannot at the same time advocate for sexism or some other form of oppression of another group. We have to be consistent in our commitment to being against oppression and for liberation. So in human oppressions, there's a tendency to, because the animals, the non-human animals down here, and a lot of human beings are brought down to the level of the animal as a form of dehumanization, there is a tendency to say, hey, we're not animals, we're humans, we're up here. So a lot of human groups that are oppressed try to step on the animal to say, no, we're above the animal, which makes us, gives us moral status because we're closer to the human proper, right? To prove moral status or to prove their human status. But as critical race scholars, Claire Jean Kim or AFCO, people who are working at the intersection of animality and critical race studies, for example, or even certain indigenous scholars are saying that this is not an effective strategy because by stepping on the animal, you're literally reaffirming the zoological hierarchy that created this animalization of certain humans in the first place. So you cannot achieve liberation for humans that are dehumanized, animalized, by continuing to oppress animals and thinking that asserting human supremacy, which is essentially what the non-oppressed group X, for example, are asserting over dehumanized humans. So it's literally mimicking what the oppressor is doing to the non-human animals. So that's not an effective strategy. What a lot of critical race scholars working at this intersection are saying that being consistent in like the principle of anti-subordination or whatever, we cannot, favor racial liberation, but then be against animal liberation. It's not consistent, and it actually does not work in our favor. It like promotes racism by doing so, and other oppressions.
Thank you. I just wanted to check, Helena, did you change your mind?
I think my question has been responded to actually, so thanks. Yeah.
Thank you. Thank you. So Pablo? Hello.
Hello. My question is for you, Paulina. I didn't know you were working on this, so I'm very happy to see that because I've done similar work, but I kind of take I'm much closer to Melissa Becca's position than you, I think. But I would disagree also with the category of legal beingness. I think we need a third category that is not that one. But what I wanted to say is, I just feel, well, first, I completely agree with everything you've said at the end now. I really think that the Non-Human Rights Project and the idea of pushing for legal personhood on the basis of practical autonomy, that kind of thinking, in my view, is ableist and very dangerous. And I think it's going to harm the movement. And people coming from critical disability studies have emphasized this for a long time, and we are not listening to that. And I think it's very important. So I completely agree with that critique. The only thing that I had because, in your presentation, you had, I think, if I remember correctly, animal property or something like that, human personhood, and then you were kind of crossed human, you crossed property, and then you got animal personhood, right? Which I really like it in terms of, so I would think my kind of ethos, if you like, the content of what the legal status of humans and animals should be coincides with your content. Where we differ, it's on the form. So one of the things that, for instance, one thing in terms of the discourse and the language that you were using now, talking about the work of AFCO, for example, is that they are working at the intersection between, say, critical race theory and critical animal studies. But that's not what AFCO is doing. AFCO has explicitly said, I am not an intersectional scholar. And it has proposed this multidimensional method of analysis or thinking. The idea is that AFCO would say, and I think that's what Melissa Becca is trying to get at with, because I think, I'm saying too many things because there are so many things in my head right now. But well, let's get with AFCO first, and then we'll get to Melissa Becca. So what AFCO, I think, is trying to say is, and Pledging Kim as well, Pledging Kim says in the Harambe essay that racism and animalness are interconstituted, are dynamically interconstituted all the way down. So they are trying to stress that it's a matter of being, the word intersection connotes externality necessarily, and interconnection overlaps. All that kind of influence, it's external, but they're saying, no, we are constituted by racism, by sexism, and so on and so on, and also the law and our political system. Now, I think what Melissa Becca is trying to say, and I think this is what the many lawyers get wrong, is that we should not read the law in legalistic terms. If we do that, we are kind of tricking ourselves, because the law is historically situated, political, intrinsically political. And yes, even though from a legalistic point of view, personhood can mean anything. It can be a corporation, it can be a glass of water, anything can be a person from a legalistic point of view. But when it comes to reality, we are subjectively anthropocentric like hell. There is a structural racism all over the place. Like one out of 3 women in the world have been sexually abused. 1 out of 10 people in the world fish for recreational purposes. In a survey of 96 countries in the world, 70 out of 96 countries in the world discriminate people with cognitive disabilities so that they don't have a right to vote proper. So in the Constitution of Australia says that people can be disallowed from voting because of their race. That's in the Constitution of Australia now. So the point is, in that context, what Siemieniec is saying is, when a judge or a legislator thinks of person, it is the human that is going to come into place. The paradigmatic human person is still there acting with full force. So the problem is not necessarily on the legal personhood. It's on person in itself, even cognitively. There is something very important in Decca's argument, I think, that I didn't see so clear in your presentation, that is a strategic argument. She's trying to say to us, we need to think of the law in historical political terms. And we need to think of who we are speaking to, who are the subjects that have to make this decision now. And the subjects that have to make this decision now are really anthropocentric. So she says, I've heard her 3 talks on this. She says, what if we were to now, we went to a legislator and said, the legal status of animals needs to change. They are not like chess or like, you know, whatever thing, a phone or something. And they will say, yeah, yes, of course, I completely agree. Like probably many people would agree with this, right? They are not like chess. And therefore the legal status perhaps should change. But then we say, then the step, well, they then should be persons. Then is where the cognitive dissonance and the legal dissonance comes into place. And that's why I think one of the reasons Siemieniec says, well, then we need a different category. Makes a lot of sense to me. Whether that's legal bigness, that's a different discussion. Because I think legal bigness, as you pointed out, it's problematic to start with because it doesn't exclude plants in a way. It's kind of so broad, so all encompassing that what do we do with it? It's very, so I'm not convinced with the legal bigness idea, but I do think that strategically it makes total sense to me to push for a different category. It's a tricky argument as well to make, but yeah, anyways, that's what I was thinking.
Thank you, Pablo. We've only got a minute or so left because I would like everyone to have the opportunity to get back into the main room for the poetry reading. So I wonder, would you like to finish? Sorry for, I know Amani, you had a question, but we may be out of time just because we have something to go straight to. But, Paulina, would you like to respond? Or would you like to take Amani's question?
Sure, I'll just quickly respond. So there's a huge debate, like originally my paper was called a multidimensional liberation theory, blah, 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 use that keyword from AFCO. But when I presented this paper before, someone mentioned to me that there's this whole debate whether her concept of multidimensionality is just a reiteration of intersectionality, of what intersectionality is actually supposed to be denoting. So I use those terms interchangeably, but thank you for bringing that up. I should probably note that somewhere. And for Siemieniec's idea of personhood, her key, she's trying to do this strategically. So she is avoiding any sort of redefinition of personhood for animals because, and I quote, of the knee-jerk reaction like humans will have to being on an equal level with animals. So if you read some of her other work, she writes about, she has an explicit non-equality stance towards animals. So that's reflected in her position of having a third legal status where animals will not be equal to humans, human persons, legal beings will not be equal. And at the same time, she just published an article on animal personhood using indigenous conceptions of personhood and promoting animal personhood. So she contradicts herself, but that's all I have to say.
Okay, thank you very much, everybody. That was a fantastic panel, really thought-provoking, fantastic papers. Thank you for the work you all do. And if you would like to leave this, you'll jump back into the main room, and I hope to see you all there, maybe this evening and also tomorrow. Thank you again for attending, and thank you for our presenters.
Thank you.